The original objective of EU competition law was the fight against cartels, which at the time were widespread in Europe. In this video, we will explore what cartels are and how the European Commission detects, investigates, and enforces against one of the most hardcore breaches of EU competition law. The hallmark of competition is that companies compete with one another for the business of their customers. Healthy competition ensures that products improve, prices fall, and ultimately, consumers are better off. However, by cooperating instead of competing, competitors can maximize profits to the detriment of consumers. Such collusive agreements or concerted practices between competitors are commonly known as cartels. The general prohibition against cartels and other anti-competitive practices between competitors is set out in Article 1011 of the treaty, which prohibits agreements which have as their object or effect the prevention, restriction, or distortion of competition. Where an agreement has as its object the restriction of competition, such as a cartel, the Commission is not required to prove anti-competitive effects, which may include increased prices or less choice or innovation for consumers. Article 1011 of the treaty can also apply to agreements concluded between companies which do not operate at the same level of the supply chain, if they restrict competition. Because these agreements are not concluded between competitors, they are not called cartels. Instead, they are referred to as vertical agreements. The most common types of collusive arrangements that cartel members will engage in are price fixing, market sharing, bid rigging, and exchanging commercially sensitive information. Price-fixing agreements are the most blatant types of cartels. Let's imagine pet food producers that sell their products to supermarkets and pet stores. In view of current market conditions and pressure from customers to reduce prices, Pet Inc. gets in touch with Catco and Zoo SPRL. They discuss via telephone and agree not to sell their pet food products below a certain price, let's say €5 per kilogram. Catco and Zoo SPRL are rather hesitant, but agree nonetheless. The three companies set up quarterly meetings where they agree on price levels in advance of every quarter. Such price-fixing cartels artificially inflate prices, leaving consumers worse off. Other than through fixing prices, competitors may eliminate competition by agreeing to divide particular markets between themselves. For instance, Pet Inc., which is based in the US, may agree with Zoo SPRL, based in France, not to export and only sell in their own geographical areas. They could also agree to customer sharing. For instance, Pet Inc. would only sell to supermarkets, whereas Zoo SPRL would only sell to pet stores. Market sharing cartels will thereby reduce competition in particular geographic areas or with particular customer groups, leading to less consumer choice and higher prices. Bid rigging is a practice whereby companies agree to collaborate over their responses to invitations to tender. Such practices are mostly encountered in industries where firms compete for very large contracts. Let's say two purchasing alliances for supermarkets invite Pet Inc. and Catco to a tender for dog toys. Pet Inc. may get in touch with Catco, requesting them to quote a higher price for one tender in return for Pet Inc. quoting a higher price for the other tender. Pet Inc. will win the first contract and Catco will win the other, without having to compete with one another. With increased certainty about their competitors' future behavior, this will result in a reduction of competition for each contract. The inflated prices will need to be picked up by the purchasing alliances and ultimately the consumers. Another more nuanced type of cartel is the exchange of commercially sensitive information between competitors. If competitors exchange commercially sensitive information which would allow them to predict each other's future behavior, this may restrict competition. Imagine that, at a trade fair, Pet Inc. shares its price lists for the next quarter with Catco. Catco, as the recipient of that information, would be able to use Pet Inc.'s price lists to adjust its own prices upwards, without there needing to be a formal agreement between the two to this end. In the absence of Catco publicly distancing itself by firmly and unambiguously rejecting the receipt of the information, both parties could be held liable for illegally exchanging commercially sensitive information. Cartel members can go to great lengths to disguise their activity by communicating via private messages using coded language or destroying emails. Competition authorities are therefore at a disadvantage when it comes to detecting cartels. To facilitate detection, the Commission has two important weapons in its arsenal. Firstly, the Commission can conduct surprise inspections at the company's premises, more commonly known as dawn raids. During a dawn raid, the Commission takes copies of relevant documentation such as emails, calendar appointments, notebooks, and meeting minutes. The Commission can also conduct interviews with any representative or member of staff for explanations on facts or documents relating to the investigation. Secondly, the Commission has put in place a leniency program that rewards companies that bring cartels to light by providing them with immunity or reduction of fines. The leniency program also has a deterrent effect on cartel formation and destabilizes the operation of existing cartels, as it seeds distrust and suspicion among cartel members. The first company to inform the Commission about the existence of the cartel, allowing the Commission to carry out a targeted inspection or find an infringement, will receive full immunity from the fine. Companies that come in later and do not qualify for immunity may still benefit from a reduction of fines if they provide evidence that represents significant added value to that which is already in the Commission's possession. The first company to meet these conditions is granted a 30 to 50% reduction of the fine. The second, 20 to 30%, and subsequent companies up to 20%. The Commission has the power to impose large fines on cartel members of up to 10% of each company group's total revenues of the preceding business year. Fines have to be proportionate, but to ensure sufficient deterrence, the fines imposed not only have to deter the wrongdoers, but also other market participants. In determining the amount of the fine for each wrongdoer, the Commission will consider the value of sales to which the infringement relates, the duration and the gravity of the infringement, as well as any aggravating or mitigating circumstances. Once the Commission has determined the amount of the fine, it will apply any reductions based on the leniency program. Finally, to speed up the procedure, the Commission also encourages wrongdoers to agree to a settlement in return for an additional 10% discount. EU competition law also creates direct rights for individuals and businesses to bring a private suit before the national courts and claim full compensation for the harm caused to them by a cartel. With the entry into force of the Damages Directive, the EU has removed the main obstacles to effective compensation, ensuring equivalent protection throughout the EU for anyone who has suffered harm as the result of a cartel. For instance, for cartel members, private actions for damages brought by customers that suffered economic harm as a result of artificially inflated prices may lead to even higher financial exposure than the fines imposed by the Commission. Cartels are by their very nature one of the most serious violations of EU competition law and can lead to significant fines. In some countries, such as the US and the UK, cartels may even lead to criminal liability and the imprisonment of the relevant individuals. While the enforcement against cartels has become less of a priority compared to the early years of EU competition law, it remains a key pillar of undistorted competition.